All right, let's pick up where we left off. I want to tell you a little bit about the process of notification. After the risk is assessed and an offender is either a Tier 1, Tier 2, or Tier 3 offender, what happens? The process of notification. And we looked at how we arrive at a tier designation, 1, 2, or 3. Now we're going to find out who gets notified and how they get notified. Everybody who gets out of prison is a Tier 1, or everybody who gets placed on probation after being convicted of a sex crime is a Tier 1. That's your starting point. And then you apply the scale and you decide whether they are Tier 2 or Tier 3, or they stay at Tier 1. Now, Tier 2 sex offenders have limited notification. Tier 1 sex offenders have the least notification. There is notification though. So, let's use this example. Somebody lives in Clifton, they work in Newark, and they have a shore house in Long Branch, and they're a sex offender. So, in Tier 1, you notify the police departments wherever the sex offender has a presence. So for Tier 1, the least risk sex offender, you would notify the police in Clifton, because that's where he lives. You'd notify the Newark police, because that's where he works. And you would notify the Long Branch police, because that's where he has a summer home. So Tier 1 is law enforcement notification. Okay? Tier 1 is law enforcement notification. Tier 2, you notify law enforcement and a few more. Tier 2, you notify institutions that are likely to encounter the sex offender, or institutions where the sex offender has a presence. So, what kind of institutions? Well, all schools are automatically included in New Jersey. Public, parochial, private, doesn't matter what kind of school it is, they're going to get notification. All licensed daycare centers, automatically included. Schools and licensed daycare centers are automatically included. All other community organizations have to apply to the prosecutor's office in order to be among the institutions that receive notification. So, for example, the Cub Scout troop, or a Girl Scout troop, a dance studio, a karate school, a battered women haven. The kind of organization has to be an organization that caters to vulnerable populations. A senior center, okay? A home for emotionally disturbed, a home for disabled persons. They're not automatically included. They have to file an application with the prosecutor's office. However, Cub Scout, Girl Scouts, and those kind of entities are the right kind of entity because that's where kids gather. The problem with them is they meet in different places all the time. You not only have to cater to vulnerable people, but you got to have a stable location. Because it's about telling the people around where the kids and vulnerable persons gather. And if you gather somewhere different week to week or month to month, then there's no way we can provide notification. But many institutions and entities are easy to notify. They have a stable location. So, like I said, a karate school, battered women's shelter, dance studio. Sometimes churches have groups that meet, or synagogues have groups that meet at that location regularly. They could apply. If the Cub Scout or Girl Scout troop meets every month at the same location in the basement of St. Philip's Church, then the Girl Scout troop could apply to be among the groups that gets notification because they meet in the basement of St. Philip's Church and there's a stable address. So schools, daycare centers that are licensed, and organizations that apply and are approved. Back to the hypothetical. Sex offender lives in Clifton, works in Newark, has a house in Long Branch. Tier 2, we would notify the police in those 3 jurisdictions, and we'd notify all of the community groups and organizations within a certain geographic radius or area near where he lives, works, or has his shore house.
You send him a letter? Or?
Well, we notify him first, because sometimes they move. So we want to notify him first. If he's like, oh, I can't deal with this, I'm moving. Well, if he moves, the process starts all over again. If he moves from Clifton to West Milford, we got to get out the scale, we got to do the scale again, we got to give him notice, because he could challenge the scale. That's why we need the support in that last box. So when he comes to court, people can debate whether the scale was properly applied. But yes, we would notify him first. In fact, he'd know about it way ahead of time, because before we do it, the government has an obligation to notify him what we're going to do, and he has a right to challenge that, and he has a right to an attorney free of charge to defend his interests, or he can hire his own attorney. But once he loses in court, if he wins, there's no notification. But if he loses in court, then we make the notification. And in my hypothetical, we would tell the schools and daycare centers and community groups near where he lives in Clifton. What does near where he lives mean? It's different for every sex offender. We have a process in Passaic County where generally, if you live in the city in a densely populated urban area, we will tell within 1,000 feet of your residence. And that's a lot of door knocks, believe me, even in a 1,000-foot zone. If you live in suburban area, if you live in Wayne or West Orange or some other suburban community, we do half a mile. And a half a mile often results in less door knocking than 1,000 feet. Not always, but usually. If you live in rural Ringwood in Passaic County or near the Pine Barrens in central Jersey, in a rural area, then we do 2 miles of your house. Go ahead, Nicole.
Who actually does that? Like, who does that legwork?
Law enforcement does it. Every county has a different process. In Passaic County, members of my office, the prosecutor's office, will collaborate with the police from the jurisdiction. So in that hypothetical, we would meet with the Clifton Police, and I would send 5 detectives. Clifton Police would send 5 officers. Sometimes they would they have special officers in some communities and in some departments where they're part-time. They help with crowd control. They may help if there's a missing person. They go look in the woods and things. They're not fully sworn officers, but they are part of a special officer program. We'd ask them, and they would maybe send 4 or 5 persons. So 15 people is a good amount of people to knock on doors. It still takes 3 to 6 hours, depending upon how many homes.
But can't they do it within that area in writing, not just door to door in person? Because when I used to run a whole series of group homes and programs and residentials in Elizabeth, we just used to get, because we were approved, we just used to get a flyer.
Yeah, but that's different. That's tier 2. Tier 2, let's stick on tier 2, stick with tier 2.
Yeah, that's what I'm saying.
I moved from door to door. No, nobody knocks on doors in tier 2.
No,
You
tier
send
3, right?
Yeah, tier 3, bear with me. Tier 2, we send a flyer to the entities. We don't go out and find the Cub Scout troop and all that.
All right, that's fine.
We get a contact person, and they get it, and they have a thing they gotta sign.
That's what I used to do.
Yeah, you used to sign the thing. It says, I'm gonna follow the rules, I'm not gonna harass this guy, I'm gonna keep the paperwork in a safe place. I'm only gonna share it in the institution with people who are likely to encounter this guy, people who are in a common area, maybe security, crossing guards. I'm not gonna give it to the principal secretary who never leaves her office, and she's not in the hallways ever. She probably wouldn't get the notification. For tier 2, because you try to keep it as narrow as possible, to protect the privacy of the registrant according to the Supreme Court and the Third Circuit. So you're correct, that's what we do. But now we move to tier 3, that's where you knock on doors. And when you knock on doors, you do the same, all the cops in the communities, all the institutions in the communities, and then you go and you tell the neighbors. And that's the geographic zones I was talking about when you go door to door. And the institutions, if there's an institution in 1,000 feet in the city, or half a mile in the suburbs, or 2 miles in a rural area, then you tell the institutions. Not all the institutions, only those in that geographic area. That's a general rule of thumb. Obviously, if Route 80's there, and it goes right in the middle of the notification zone, you're not going to cross Route 80 and tell the people on the other side of Route 80, because that's not really his neighborhood. So maybe you would only do a half a mile there, or 500 feet, whatever it is. So when you go door to door, you get the Clifton Police, and in Newark, a little bit different now, if it's door to door, you tell not only the people who live in his neighborhood, but if he's at tier 3 and he works at the Coca-Cola bottling plant in Newark, you tell everybody at Ground Zero. Ground Zero is the Coca-Cola bottling plant. Everybody in the Coca-Cola bottling plant gets an individual flyer. All the neighbors around the Coca-Cola bottling plant within 1,000 feet get a flyer. You go down to Shore House, the Long Branch Police come out. Prosecutors from State County go down there. The Monmouth County prosecutors will give us some folks. We go within whatever he lives in Shore House, maybe it'd be a half a mile, maybe it's suburban. We do door to door down there too. This is worst case scenario. Very few sex offenders have a beautiful home on the Manalope. But if they did, that doesn't mean there aren't affluent sex offenders. There are sex offenders from all walks of life and all economic backgrounds. But nevertheless, so that's what you would do, tier 1, tier 2, tier 3. And that's how you do notification. It's changing soon. They're going to move to a totally text messaging and internet-based notification in the near future.
Facebook notifications.
I don't know about Facebook, but social media may be part of it.
Oh.
You can follow your State County sex offenders on Twitter.
Even though they don't have a page?
Well, we're going to make a
They'll
page.
probably have a page with all their names.
And the level of risk, this risk assessment scale is going to go in the circular file cabinet. They're going to get rid of it. And it's going to be based upon how serious the offense was. So it's automatic. Risk is assessed by the crime you committed, not by this. This is the better way to do it if you want to truly evaluate risk. You know, because like I said, there's first-degree offenders and first-degree offenders. First-degree offender who, molested his stepdaughter, and a first-degree offender who, rapes women at the bus depot. But that's the way the law is changing, and the world's changed since this law passed in 1994. I mean, I've argued for this since the late 90s that we should get rid of this. I said, we're using police strategies that date back to the sheriff of Nottingham. These are the kind of things that we did with Paul Revere. He went on his horseback. The British are coming, the British are coming. Now you just got to put it on the web and people can find it out the easy way. You don't need to go on horseback and knock on people's doors.
Wasn't there a sex offender website registration for?
Well, yes, thank you for pointing that out. They are put on the internet for the past decade, but not all sex offenders. Only tier 3 and some tier 2s, the predatory ones. The incest offenders,
High two.
not high 2s, only 2s that are not incest offenders or juveniles. However, if a juvenile has multiple offenses, or an incest offender has multiple offenses, they go on the internet. So all tier 3s on the internet, among tier 2s, the ones who are not incest offenders or family offenders and not juveniles. Juveniles are excluded, and people who molest within the family are excluded. Unless you have multiple offenders, an exception to the exception. And the exception to the exception is if you're an incest or family offender who's done it twice, then you go on the internet. If you're a juvenile who's done it twice, you go on the internet. That's why when you go on the internet and look up the people who live near you in your house, you can do that. It's on the state police website. It's not a true picture of the sex offenders who live near you. It's just some of them, if any. I would look at familywatchdog.com. That's like a bunch of militant mothers run that thing. They're better than They're far better than the state police at doing this. No knock on the state police. It's not their fault. but the militant mothers run quite a website, familywatchdog.com. And the reason is, if you move to Florida, right, you have to register under Florida law. Florida law is quite different than ours. Louisiana's got the best one. You know who's got to go door to door to hand out the flyers in Louisiana? The sex offenders.
You have to identify themselves at every door.
And they give you a bumper sticker. If you have a car, you got to put the bumper sticker on your car. I think they got rid of that, but that was a little too rich for Louisiana, but. Anyway, they may have changed that law. That was proposed, and I think it was a law for a while, but I'm not an expert on Louisiana law.
You don't want to be embarrassed, don't text nobody?
I'm with it.
There you go. Now, this is why the Family Watchdog website's better than the state police. Because let's say you're a tier 1. You don't go on the internet in New Jersey at all. But if you move to Florida, you're going on the Florida internet. Well, not the internet, because you're a Florida residents. Your internet's World Wide Web, right? So now you're in Florida, you're on the internet. No matter what tier you're on the internet. You move from Florida back to Clifton, right? They come to New Jersey. I can't put him on the internet in Passaic County, Clifton, because he's a tier 1. But he was already on the Florida website, so the watchdogs, they know who he is. They keep him on there. They don't believe him. Oh, he lives in New Jersey now. They just keep him there. Formerly lived in Florida, and they have to tell Florida where they're moving to. So if they live in Fort Myers, Florida, they have to tell the Fort Myers police, I'm moving back to 123 Paulson Avenue in Clifton. So now the militant mothers got him at 123 Paul. They got the right act. They're good. They're better than the state police.
Where are the limits, I know juveniles are different, the juveniles like in high school? Because I used to have issues when I occasionally would take foster kids in that were tier 2s when they were on a pinch. And registering them for school, school has to be notified, but I used to have issues with schools, and I'm like, no, whether every single teacher on their 9 classes had to know, but technically they're monitoring, and it was this whole gray area, an argument, and they're juveniles, and they're protected, but they're not, and it was this whole big mess.
The Megan's Law and the level of risk doesn't care about schools and buildings and institutions. It simply cares whether you're a risk to reoffend. So if you have a tier 3 juvenile who goes to Clifton High School, tier 3 now, I know it's the highest, he goes to Clifton High, we have to tell the people who live within 1,000 feet or half mile, whatever it is, suburban or urban, let's say 1,000 feet of his home in Clifton, and he's in school 8 hours a day, 6 hours a day, whatever it is, we have to tell the people within 1,000 feet of the school, because somebody walking in their car by his house is just as vulnerable to his predatory behavior as someone walking to a grocery store near Clifton High if he's so inclined to molest again. So we tell everybody within 1,000 feet of where a school is, and anybody who works there, because they're part of the population that's at Clifton High. They wouldn't that be sad if we can't tell the teachers, it would embarrass them, so we don't tell the teachers, and some substitute's walking to her car at 6 at night, he rapes her.
Yeah.
Well, why wasn't I told? Well, we don't want to embarrass, we only tell the neighbors, not the people who are at ground zero, so. But that's only tier 3.
Right,
Tier
the
2s, you
are
wouldn't,
really the constant
yeah, you're not supposed to tell the,
arguments.
some lesser group of teachers is supposed to get the flyer. And they don't get it, they're supposed to just show it to the teacher.
Right, they're not supposed to have it in their possession and
Precisely.
distribute on their own.
Exactly. Okay, any other questions about Megan's laws? I think we pretty much covered it. All right. Also part of this learning module was something related to Megan's laws called the civil commitment statutes. I'm not going to spend a lot of time on it, but in 1994, when Megan's Law was passed, it was part of a package of laws to help protect the public from sex offenders. This case was inspired by not Megan Kanka, but a little girl named Davina Janayo, who lived in Passaic County, the city of Passaic. It was a case that got national coverage because a man named Conrad Jeffries, who had multiple sexual homicides in his background, Conrad Jeffries took Davina from the street, took her into his apartment, and he raped her and then murdered her and he was caught as he was murdering her by the Passaic police, but she died. I did a presentation 2 or 3 days ago from at Passaic High School, and one of Davina Gennai's playmates was in my audience now. This was 20 years ago, whatever. She's now a young woman, and she's like a social worker at the school, and she used to play with Davina. She got upset. I talked about the case, and she got upset by it. But she came back in the room, and she told me her experiences with that case. And what happened was, Conrad Jeffries got out of prison, and he had served his full sentence. There was no way to put him back in jail, but he was a danger. So Megan's Law is one thing, but people said, why is he out? He's mentally unstable. He should have been screened on the way out for civil commitment. And they really didn't have to do this. There were already laws on the books for civil commitment, but they made a new process whereby everybody who gets out of the state prison system, or any prison system in New Jersey, has to be screened for mental illness. And the assumption is that if Conrad Jeffries was properly screened, he would have been institutionalized, and he wouldn't have been in a position to kill Davina Gennai. Those are called the civil commitment statutes. What they did pass that was a little bit different was the sexually violent predator laws. And this gets a little complex. I'll tell it to you, but you're not responsible for remembering this nuanced application of our mental health law. But in order to be civilly committed in America and in New Jersey under our Constitution, any one of us, if 2 doctors agree we're mentally ill and in danger to ourselves or others, they can institutionalize us, take us away and put us in a mental health facility until we're no longer dangerous. But they have to suffer from a verifiable mental illness. Now, mental health professionals, psychiatrists and psychologists have said for years, some people aren't mad, they're just bad. Essentially what they're saying is they don't have a mental illness, they're just antisocial. And antisocial isn't a mental illness, it's a personality disorder. It can be a personality disorder, but physicians, their bread and butter is diagnosing people. You diagnose someone and you can treat. Some people are they're psychopaths. There's no treatment. They're psychopaths, they're antisocial, and they would say to criminal justice, you guys need to lock them up longer. We can't do anything for them. So because it wasn't clear how to apply standard civil commitment law to some sexually violent people, they passed a law that requires something less than a mental health diagnosis. If you can be classified as a sexually violent predator, which is described or defined as a thought disturbance, which isn't a mental health word, it's a word that the lawmakers made up. But there's some rigorous definitions that have to apply. You can be civilly committed under the sexually violent predator statute. You may not suffer from a classic mental illness. You may suffer from a thought disturbance that makes it likely in the very near future you're going to rape somebody. And in Kansas versus Hendricks, this process was upheld by the United States Supreme Court. And nearly, if not every state in America now has sexually violent predator statutes, whereby people who are a high risk to rape and molest can be institutionalized. They have to get treatment though, and they can be institutionalized and treated and taken off the streets. That was passed the same day as Megan's laws, but a lot of people that doesn't get as much press and notoriety as Megan's laws. Sexually violent predators and civil commitment statutes. Megan's laws, sexually violent predators and civil commitment statutes were passed on that same day. Any questions about that? Yes?
Yes, for the first one, can you give a clear, definition of the civil commitment statute? Is that you have to be screened? Can you say that again? I just want to clear that.
Well, I'm paraphrasing, and if you remind me and post in the Cyber Cafe, I'll look up New Jersey law on it, but essentially, you have to present an immediate danger, an immediate serious, I'm paraphrasing, an immediate serious danger to yourself or others or property in order to be civilly committed. And you have to present that danger as the result of a mental illness. So you have to have a diagnosable mental illness that causes, it could be schizophrenia, bipolar disorder, it could be a number of different mental illnesses that are recognized by the psychiatry profession. But if you suffer from a diagnosable mental illness that makes you an immediate, the way they say it is you're a danger to yourself, others, or property in the reasonably foreseeable future.
You can be civilly committed.
Civilly committed. That's anybody. And that happens a lot. There are people that are dangerous to themselves. So they may start fires or cut themselves and try to commit suicide, different things like that. Now, that's a little bit different than sexually violent predator statute. And the way I was trying to differentiate them was to let you know that under classic mental illness law, psychopaths, antisocial persons that are just sociopaths, that just are bad criminal people, don't have a diagnosable mental illness. If they're going to rape or molest, there's another law called the sexually violent predator statute that you can also be screened for. And if you have a substantial thought disturbance that in a reasonably foreseeable future would cause you to rape or cause serious sexual harm to somebody, again, I'm paraphrasing, you could be institutionalized that way. Now that, you're not going to regular mental health facilities though. They built a special place right in the shadow of Rowway Prison over there in Kearney. It's in Kearney. And it's the last place you want to be in this country, or in this state, is that place. Any other questions about special laws to protect children, including Megan's Law, civil commitment, and sexually violent predator statutes? Okay. Well, I'm going to talk now about mandatory reporting in our state, and that's Chapter 3 in Meyer's book, Child Abuse Reporting Laws. And the mandatory reporting laws arose in the early 1960s, and that was the year that a famous pediatrician, at least in child maltreatment circles, named C. Henry Kempe, published a landmark article called the Battered Child Syndrome. Battered Child Syndrome. Now, battered child syndrome is a medical diagnosis, and generally speaking, it describes a series of injuries that are in various stages of healing committed upon a child by a caregiver. Well, shaken baby is child abuse too, but that can happen in one single incident, right? Battered child syndrome is the continuous battering of a child. So you can have scratches and bruises and burns that each in and of themselves, are not that serious, but collectively can be part of a battered child syndrome. But battered child syndrome is usually investigated, and we're able to prosecute for battered child syndrome when you have various injuries, multiple injuries in various states of healing upon a child. You got you have a 3.5-year-old goes for a full body scan. They have 2 healed broken ribs that are 18 months old, give or take. Doctors have a tough time with the age of injuries, but they can get you in the ballpark. 2 fully healed fractured ribs, a fractured jaw that's 4 months old, an acute slice on the ear that's scabbed. You look at all 3 of these things, and a doctor can diagnose battered child syndrome, which means that the child has been battered by a caregiver over a period of time. Anyway, Kempe described that in 1962. And he also made the observation, as many did, these things happen in family homes. It's nearly impossible to discover. I gave you 2 examples of healing fractures that no one ever knew about, because these things happen, inside the family home. And unless people who interact with the kids every day, who are in a position to observe kids or listen to kids outside of their family home, outside the scene of the crime, we won't be able to detect this, and they will be the silent sufferers. So in order to identify who these kids are, New Jersey and states throughout America began to pass mandatory reporting laws. that if you are suspicious of child abuse, you gotta report it to child welfare authorities. If you have reasonable cause to believe that a child may have been abused or is being abused, you have to report that to child welfare authorities. And that arose out of C. Kempe's landmark article in 1962 describing the battered child syndrome. The federal government started a conference that year on child abuse, and the conference attendees recommended a number of laws. Among the laws recommended was mandatory reporting. By 1965, the American Medical Association, the American Humane Association, the Council of State Governments, the Children's Bureau of the U.S. Department of Health, Education, and Welfare all published model child abuse reporting laws. Different samples, if you will, for states to pass. Now, all states have mandatory reporting laws, and they come in a couple of flavors. For your purposes, you have to know this. Some states are any person states. Put the words any person in quotations. Any person. New Jersey's an any person state. That means any person who has a reasonable suspicion that a child may have been or is being abused, sexual or physical or any other emotional, psychological neglect, you have to report it to child welfare authorities. In New Jersey, it's DCP&P. Okay? DIFAS. You have to report it to DIFAS in New Jersey. What is it? The Department of Child Protection and Permanency?
This week, right?
Well,
Nope.
it's that. So you have to report it to Child Protection in New Jersey. Any person. And if you don't report it, it's a disorderly person's offense, punishable by 6 months in prison. So not only do you have mandatory reporting, the failure to report, to knowingly fail to report, is a disorderly person's offense in New Jersey that can result in up to 6 months incarceration. On the other hand, if you do report and you made a mistake, you got it wrong, you overreacted, you cannot be successfully sued, and you cannot get in trouble in the state of New Jersey. You have immunity from prosecution or civil lawsuits. Okay? So that's how important it is, right? If you don't do it, you can go to jail. And if you do it and you mess up and it's an honest mistake, you cannot be prosecuted and you cannot be successfully sued civilly. You have immunity. Other states have what they're called, open quote, mandated reporter laws. Not New Jersey. New Jersey's an any person state. New York. Some states have, open quote, mandated reporter, close quote, laws. That means they have a list of people who have to report if they have a suspicion. Who do you think might be on that list? Doctors, next. Teachers, next. Therapists, next. Lawyers, law enforcement. Courts, clergy. Now, I don't know who's on any particular states.
Other
Child welfare authorities, people like that. Mandatory reporting, other child welfare agencies, yes. Mandatory reporting. Mandated reporter states have a list of persons. And if you're on a list, you don't have to report. You could report, we encourage you to report, but you can't be held responsible for not reporting. It's not mandated. So you have your two flavors. Any person, New Jersey, and some other states, including New York State, which is a mandated reporter state. Famous case from the past 18 months that is not an any person state. Take a guess. What was the most notorious child abuse case in the past century that was not reported promptly? Say it. Come on, our minds, we forget the most notorious child abuse case
in New York.
in the past 100 years. It's not New York.
Oh.
It's not New Jersey.
Remember that case?
The most notorious child abuse case in the past 100 years that wasn't reported. Failure to report. Jerry Sandusky?
Oh.
What are you talking about? I'm talking about failure to report. A boy was being sodomized with his face pressed against the shower
And there's so
stall.
much other-
He was anally raped and a guy watched it and no one reported it for a decade. Now, I don't know about the most notorious child abuse case that wasn't reported. Failure to report. Failure to report. And the guy was let back on the campus. Pennsylvania is a mandated reporter state. They got a list. So they probably added after the horse got out of the barn. Football coach. Wasn't on there before, probably on there now. As of 1998, when Professor Myers wrote this book, at least 40 different professions were specifically named in mandatory reporting laws. So we came up with about 10 of them. There is no discretion. You must report. Mandatory reporting leaves no room for discretion. If you have a reasonable belief, or whatever the standard is in any particular state, you must report. You must. And the obligation to report child abuse trumps, abrogates, outweighs any other rules or statutes of confidentiality or privacy. Everyone. Things you say to priests, things you say to your husband or wife, things you say to your lawyers, the confidential relationship among patients and psychologists, the things you say to your doctors. Child abuse reporting trumps or outweighs, or as they say with fancy language, abrogates every rule of confidentiality. There's no exception. None. Zero. So, it's not discretionary. It trumps all privacy and confidentiality law. And if you don't do it, you can go to jail. And if you do it, you cannot be successfully sued. Pretty important stuff. You know, if you're in the Patterson area on Friday, I'm doing a 30-minute workshop on what we now call IPV, intimate partner violence, domestic violence, and that's not my expertise. I don't know a hell of a lot about it at all. But my colleagues in my office are experts on it, and they're putting together this conference at Passaic County Community College, and they asked me to talk about child abuse and its interrelationship with intimate partner violence. And we know there's a strong correlation between child abuse and domestic violence. But my presentation, and I'm researching this now, I don't know a lot about it, but I love dogs. I love little puppies and dogs and big dogs and fat dogs and ugly dogs. I love all dogs. And I think one of the things I do when I retire, maybe to move to one of those rural areas where you get 2 miles of notification under Megan's laws and have a few dogs that can let them out and they run and scamper or wildly in the backyard. Not have to worry about cars hitting them or people stealing them or whatever. I want to be surrounded by dogs. Humans, they can go to, I'll drive to see them. When I wake up in the morning, I want to see puppies and dogs chirping and barking. I like cats a little bit too nowadays. What I'm going to be presenting on is the interrelationship between animal abuse and intimate partner violence and child abuse. And when you go into the home of a batterer, you're not only going to find a battered woman, you'll find a battered child and a battered animal. And sadly, it usually starts with the animal. And children suffer not only because of what the batterer does to their mom, but because of what the batterer does to their animals. So I'll be talking about that on Friday, and it's so important to me that what my workshop is designed to do is not only identify the problem, which is easy to follow, but suggest ways to combat it, ways to deal with it, right? It's easy to go, people who beat up ladies, beat up dogs and kids, right? They do. But what about that? How can we change the law to protect the animals and the kids and the ladies and the men and intimate partners? Well, one way is, why not have mandatory reporting for people who batter dogs? You know, 1962, Kennedy said, you got to report this stuff. Why don't we do this? Well, within 2 or 3 years, every state in America had mandatory reporting. We still do. Why not have mandatory reporting if you have a reasonable suspicion that an animal is being battered or abused? Okay? So that's one of the things that we can do. It's one of the things that we can do as a society, is take the battering of our animals, our companion animals, that mean a lot to families and kids, take it seriously and have that stuff reported. Because I suggest to you strongly that when you go in the homes where people batter animals, you're going to find battered kids and battered people. Okay? And kids suffer silently not only because they hit mommy, but because they hit the animals. And they watch that and they hear that. And that's emotional abuse in my book. So, mandatory reporting has been around for decades now, and not everybody follows it. You know, you say, oh, it's such a compelling thing that there's all these rules associated with it. You can get in big trouble for not doing it. You know? How come everybody doesn't follow it? Why do people knowingly violate the mandatory reporting laws? Give me some answers. You read chapter 3. Why do you think that people don't? Even some psychologists violate it, and medical professionals, and teachers. Why would a teacher not call DCP&P when they have a reasonable suspicion that a kid's being abused? Go ahead.
I think it has to do with their environment. If it's known as a good school, they don't want to bring any, like a bad image towards it, because nothing with life is kind of correlates to something good.
Okay, so they may not want to be embarrassed or bring shame upon the school that they work in. And that may be, that certainly is Joe Paterno's legacy, sadly. You know, Penn State, that's in part, a large part of what motivated them. Go ahead.
I was gonna, kind of building off of that, I know my roommate is a teacher, and they're in a nice school district, and it's a directive from the principal that they are supposed to report their concerns to them, and then the principal will never call it in.
Yeah, well, what community is it?
Westfield?
Okay, that's in Union County.
Yeah.
Yeah, well, one of the things that I'm doing now is I made a video. I told you about this already, the video we did in 2007, blah, blah, blah. Anyway, I made a video in 2007 with some grant funding, and it's all about mandatory reporting. And I was going to hand out this to everybody, and I did over the years since 2007, but, you know, I want to teach schools and institutions the right thing to do. They just want information, you know. They want to do the right thing, and they think they're doing the right thing sometimes, and we're going over the reasons why they don't report it. But they really want the information, and not everybody gets the information. They get misinformation. You got principals that act like that, and that's never good. So what we did was I took the video, and I partnered up with all the schools in Passaic County, and we got another, whatever, $18,000, $19,000. And I hired a web designer, and we created a little website where everybody in Passaic County schools, from the maintenance persons to the cafeteria people to the county district superintendent, who makes 4 times the amount of money I make, has to watch this 12-minute video. When they're done watching the 12-minute video, they answer 15 questions. The 15 questions address things like that. Is it okay if I merely report it to the principal and the principal blah, blah, blah? No. You select no, that's correct. Because if you do this, this could happen and that could happen and blah, blah, blah. You have to get all 15 questions right. If you get 4 questions wrong, you cannot move to the next level. You have to go back, watch the video again, and answer the next 4 questions. You know what? If you watch the video, you get all 15 credits right. If you space out, like, oh, look at the butterfly, you're not going to get all 15 credits right. Once you do that, you click the next thing, tells you, congratulations, you successfully completed the 15 questions, and you print out a beautiful certificate signed by my boss, the prosecutor of Passaic County. You have a certificate in mandatory reporting for educators. Put it on your wall, and so be it. And the point is we know what the law is. We're talking about it now. It's how to apply it, man. How to apply it. How to know when to report and when not to report. How to appreciate what DCP&P does. How not to look at them as an adversary, but rather as an ally. How not to let past experiences with DCP&P impair your judgment about this kid. I don't care if you call DCP&P on the old case and things didn't work out like you thought. What about this case? That's an awesome thing you're doing if you're not going to report this case because you had a bad experience with DCP&P on the last case. I'm not picking on DCP&P, but one of the reasons in this book is they don't trust child welfare to do the right thing. We know what the right thing is. They don't. Or they may have had a past experience where it didn't work out so well with DIFAS or child protection. So, you know, the hope is, And their other one is, well, what if I'm wrong? It's okay to be wrong, man. Stop worrying about being wrong, right? Well, what if it isn't true? It's not your job to figure out when it's true. That's what governs most principals and most education professionals. They want to screen it. They want to ask questions. I was in court today with this woman, Kristen Leone, who's a teacher at Clifton High School, had sexual relations with one of her students. The lady who got the information sat on it Thursday, Friday, Saturday, Sunday, Monday. Finally, her father was an educator, and she said, Dad, I got this. What do you mean you didn't tell him? You got to report that, the father says, right? That morning, she calls it in. Okay? Well, that wasn't the only part of this where mandatory reporting failed. The principal called in the witnesses. Bring in the boy. You said this happened. Are you sure? Where did this happen? Bring in this other kid. Oh, were you there? He says you saw what happened. He told you. He conducts his own investigation. Then they call the lady in, the accused.
Wow.
Then they tell her, you better bring a union rep. Are you kidding me, man? How am I going to interrogate that lady? How am I going to interview her? How am I going to interview her in a law enforcement context?
Wow.
Okay, needless to say, she hired a lawyer before I met her. Sadly for her and stupidly for her, she left the condom in the garbage pail in her bedroom. So that came back from the state police. It's obviously her. Point is, institutions mess up all the time. This will not happen in the future. If you watch my little video, it'll create a culture that's different. Because everyone will know what the rules are. And the principal won't be the super dude. I know, I'm a smart guy, I know everything. Even the cafeteria workers say, that's not what I learned. No, I want to create an environment of peer pressure to do the right thing. Because there is this interest in protecting the school, its reputation from harm, protecting, the legacy of the school, protecting how people view the school. All institutions do that. It's not only schools. The Roman Catholic Church should be indicted in 11 different jurisdictions in the United States of America. They've done this going back to the year 900, the Roman Catholic Church. They've done it as recently as the 70s and 80s in the United States of America. They're just another institution, okay? It happens in the Jewish community all the time, where the people hunker down and they won't report it, okay? A lot of issues at work there, but they don't report it. They think they can handle it themselves. They don't want to bring shame. There are other cultural issues that impact upon the desire to tell. Okay? It has to be reported. So the hope is that when everybody watches this video, okay, that everyone from the cafeteria worker and maintenance right up to the district superintendent will know the right thing to do. And you won't ever have a Sandusky again. And you won't have a case like Clifton High that almost imploded because the lady was forewarned, So we want to try to combat these kind of things. We want to try to combat your principal. There's a number of things here. Other educators and psychologists say, will it do more harm than good? Because they know the kid. They say, if I report this kid's going to be destroyed. I know her mother. It's not a big deal. Okay, so she looked her with the belt. We can take care of it in here. If I report it, bad things are going to happen. So they do their own judgment on what the right thing to do for this family is. Okay? And they're not alone. It's all around the country. They think the evidence is insufficient. It might do more harm than good. If they're a counselor, they think it will undermine therapy. So they worry about that, whether it undermines therapy. Okay? If it's not that serious, they may not report it. It wasn't that big a deal. I don't want to create something, make this into a big deal. So those kind of issues impair the judgment of professionals and persons who have this information. All of those are illegitimate in my view. Simply report it. And they think that we, child protection and law enforcement, overreact. Let me tell you something. We got more than enough cases. I think we neglect more serious cases than we intervene in cases that are de minimis or not serious. We don't go around getting involved in cases that are minimal or not serious, okay? We may screen them, but we don't get involved in them. So the fear that we're going to overreact is misplaced, I think. I don't think we get involved in enough cases. And we got more than enough cases to get involved in a case where there's weak evidence or insufficient information or we're going to do more harm than good. Anyway, enjoy your time in South Padre Island. I want you to have fun on the beaches of Daytona. okay? If you're going to Cozumel or going off the coast of Venezuela, send me an email, okay? I want to picture you drinking a pina colada with a wedge of orange in there and a big straw. If there's a parrot or a macaw over on the side squawking, take a nice picture with the parrot for me. Enjoy your spring break. I'll see you next week.